Test 1, 2, 3. All rise.
Simone?
Good morning, Your Honor. We are here in case 26 CR 386, State of Ohio versus Laura M. Kovach. Present in court is a defendant who is accompanied by her attorney, Mr. Samuel Smith. We are here today for a change of plea hearing. It is the state's understanding that the defendant intends to withdraw her previously entered plea of not guilty and enter a plea of guilty to a lesser included offense of count 1, domestic violence, a felony of the 4th degree. There is no agreement with regard to sentencing, and the state would request a pre-sentence investigation report. Thank you, Your Honor.
What's the reason for the reduction?
For purposes of the plea agreement, the state would agree that there was one prior conviction for domestic violence.
I guess what's the reason behind the state agreeing to a reduction?
Just based on the facts and circumstances of the case.
Okay. Mr. Smith, does that all sound accurate?
Yes, Your Honor, that is accurate.
Ms. Kovach, were you able to hear what the prosecutor just had to say regarding what she believes your intentions are here this morning?
Yes, sir.
She indicated to the court she believes it's your desire to withdraw your previous entered plea of not guilty and plead guilty to a lesser included offense of domestic violence, a felony of the 4th degree. We would then defer sentencing to get some reports completed, come back on a future day where there is no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, and most importantly, what you want to do this morning?
Yes, sir.
Well, before I can accept your guilty plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I am going to ask you a series of questions. If at any point when I'm asking you the questions, if you're unsure, unclear of anything I'm asking you, you need anything repeated or clarified, if you'd like a moment to talk with your lawyer so you could ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
All right.
All right, let's get started then. How old are you?
47 years old.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that, or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came to court here this morning, have you any drugs or alcohol of any kind?
No.
What about within the last 48 hours?
No, just medication at the jail.
Well, what prescribed medication have you taken in the last 48 hours?
Depakote, Boost Bar, and Gedon. Propalo.
Hang on. Depakote, Buspar. What else?
Gedon. Propalo.
What was that last one?
Propalo. It's a heart and blood pressure medicine. What else? Prilosec. Synthroid. And I believe there's one more in the morning for like medical. Shoot.
What's the last one for? You don't remember?
The Prilosec, the Synthroid.
I know what those are for.
There was another one, the Propalo. And then Buspar, Gedon. I think that's it right now. And then, yeah.
All right, well, I wrote on this form, it says, I'm not under the influence of drugs. Well, let me ask you this question first. Do any of these medications that you've just taken within the last couple of days, do they affect your ability to understand or appreciate where you are, what's going on around you, or negatively impact you in any way?
No.
Okay. Well, in the form that you looked at previously, it says, I'm not under the influence of drugs or alcohol, and I have not taken any drugs or alcohol in a 48-hour period preceding this hearing. And I added, except for Depakote, Buspar, Gedon, heart and blood pressure medication, Prilosec, and Synthroid.
Correct.
Does that sound accurate?
Oh, that's accurate. I mean, sorry.
All right. Now, did you receive, well, I know you did receive a copy of this indictment. You got it back about, a couple months ago. No, that was when you were bound over. You got it about a month ago, a little over a month ago.
Yeah.
That's the document that sets forth the charge. Do you remember getting that?
Yes,
And you had a chance to look that over at some point?
yes,
Now, in that indictment, you're charged with one count, and what's alleged here in count one is on or about March 17, 2026, in Eastlake, Lake County, Ohio, that you did knowingly cause or attempt to cause physical harm to Michael Agapi, a family or household member. It's further alleged you have previously been convicted or pled guilty to 2 or more offenses of domestic violence, that being the Lake County Court of Common Pleas on February 18, 2025, the Lake County Court of Common Pleas on July 10, 2024, the Mentor Municipal Court on August 10, 2022, and the Willoughby Municipal Court on June 27, 2007. That conduct with those prior convictions constitutes the offense of domestic violence. It's a felony of the 3rd degree. Do you understand what you're charged with? What you're charged with in this count? You're not pleading guilty to that charge, but that's what you're charged with. You understand
Yes.
that? Any questions about it?
no,
Now, for purposes of the plea today, the state has agreed to delete 3 of those convictions that are listed in that second paragraph, so there'll only be 1 alleged prior conviction. And the difference with having only 1 prior conviction versus 2 or more is that it reduces it from a felony of the 3rd degree to a felony of the 4th degree, which is less serious. There's a big difference between a felony of the 3rd and 4th degree. But that's what you'd be pleading guilty to. You'd only be admitting to having 1 prior conviction, which would make it a felony of the 4th degree, for purposes of this plea. You understand that? Your client's trying to talk to you.
No, he's getting the prosecutor's getting rid of the prior convictions, which will allow it to be reduced down to a
Okay.
lower charge.
okay, now I understand, okay, sorry.
You have any questions for me about it?
No,
Okay. So for purposes of the plea today, the state has agreed to allege that you have previously been convicted of 1 prior conviction.
Okay.
And again, that makes domestic violence a felony of the 4th degree, and it reduces it from a felony of the 3rd degree, which is what you're charged with.
okay,
You understand that?
yes,
Any questions?
no,
Well, then before I can accept your guilty plea, I need to make sure you understand all the rights you are giving up by pleading guilty. And you first of all have a right to a trial. Now, a trial could be to me as a judge, where I listen to all the evidence and I make that decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. And a jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jury would consider and weigh all that evidence, and the jurors would make that ultimate decision. And that ultimate decision reached by those jurors would have to be unanimous. Unanimous means all 12 jurors would have to agree together, one way or the other, whether you're guilty or not guilty. Do you understand that?
yes,
Do you understand by pleading guilty you're giving up your right to have a trial?
yes,
Now, if you had a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it's her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of this charge, and that presumption of innocence stays with you and remains with you until the state, if at all, is ever able at a trial to overcome that presumption of innocence and prove you guilty. Do you understand that?
yes,
Now, when we speak of this burden of proof, since this is a criminal case, the burden of proof is what we refer to as proof beyond a reasonable doubt. That's the highest burden of proof there is in our justice system. What it actually means, it's the amount of the evidence and the quality of all that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or part of the charge beyond any reasonable doubt before you could ever be found guilty of this charge at a trial. Do you understand that?
yes,
Do you understand that by pleading guilty, you're giving up your right to have a trial in this case?
yes,
And make the state prove you guilty beyond a reasonable doubt? That's what happened. You're giving up your right to make the state prove you guilty beyond a reasonable doubt at a trial by pleading guilty. You understand that?
I'm gonna plead guilty.
But you understand that's what you're
Oh,
giving up?
yes, yes,
Okay.
sorry,
Now, in order to try to prove you guilty, if we were going to have a trial, the state would bring witnesses into the courtroom to testify for the state, and they would answer questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions. That's called cross-examination. So he could ask him anything he wanted to, but within certain rules. Do you understand that?
Yes.
Do you understand by pleading guilty, you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, sir.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not obligated or required to do that. But you have a right to do that if you want to. Do you understand that?
Yes.
And you further can request the court issue an order. That order we call a subpoena. And what a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if there was anyone out there that wasn't willing to come in voluntarily on their own and you wanted to have them testify. You understand that?
Yes.
You understand you're giving up that right?
Yes.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here, she's not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes.
Further understand that if we went to trial and you were found guilty of this charge, you would have the right to appeal or challenge that guilty finding to another court, a higher court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding that I'll enter if I accept your plea, as well as any other issues that you could have raised or brought to my attention up to this time. Do you understand that?
Yes.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, sir.
Do you understand them all?
Yes.
Do you still want to plead guilty?
Yes.
Do you understand that your guilty plea is a complete admission of guilt? That means you're going to be admitting to the facts being alleged here. We're not going to argue that you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of that guilty plea is that you will be found guilty by the court, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes.
Now, as far as sentencing goes, you're pleading guilty to a felony of the 4th degree. It's the reduced charge. This offense is punishable by a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes.
Now, obviously, I'm aware that you're on probation to this court and 2 other cases. Are you on probation anywhere else?
No, sir.
Do you have any other charges pending against you anywhere?
No.
And I do need to advise you, and I know you're aware of it already, but you're on probation to this court in 2 other cases. So if you commit a new crime while you're on probation, a motion to terminate your probation or community control sanctions could be filed. In fact, it has been filed in both of those cases, and that those motions are pending based on the outcome of this case. But there can be consequences in those other 2 cases as a result of pleading guilty here and being convicted of a new offense that you committed while you were on probation to this court in those other 2 cases. You understand that?
What's that mean?
That means you're on probation in those other 2 cases, and you were advised when you were put on probation that if you ever violated the conditions of your probation, your community control sanctions could be terminated, and you could be sent to prison for those cases for violating your probation. The 1 case, the 23 case, you face up to 18 months in prison. The 24 case, you face up to 3 years in prison. So if you're convicted in this case, which you would be if you pled guilty and I accepted your plea, we're going to have hearings on the other case to see if your probation should be terminated and what should happen there. So there will be consequences in those other cases as a result of pleading guilty here. Do you understand that?
Yes.
You have questions for me about that?
I don't think so.
Do you have any questions?
No.
And those consequences, I mean, ultimately could be you go to prison in those other two cases. If that's what I determine, that's not automatic. We'll have hearings on those cases, and we'll come back for sentencing on all three cases, the two older cases, and then this one will be sentenced all at the same time.
Oh, at the same time?
Yeah.
On the 6th?
Well, whenever that is, I don't know what the date is, but
Okay.
we'll come back and we'll have the sentencing on all three cases at the same time.
Okay.
But I want to make sure you understand that as a result of pleading guilty here today, that can result in consequences in those other cases. You understand that?
Yes.
Now, if a prison sentence is imposed in this case, and it's imposed in the other cases, as the judge, I have the discretion to run those prison terms either concurrent or consecutive. Concurrent means you'd serve those prison terms together all at the same time, whereas consecutive means you'd serve whatever sentences were consecutive one after the other. You'd finish the prison term on one case, then serve the next, and then serve the next. You understand that?
Yes.
So in this particular case, your maximum prison sentence you face is 18 months. With all three cases, you're facing a maximum prison term of 72 months or 6 years. Do you understand that?
Yes.
If a prison term is imposed in this case upon your release from prison, you could be placed on what is called post-release control, sometimes called parole. That's a period of supervision you would be on after you completed the prison sentence. And in this particular case, it could be up to 2 years. Do you understand that?
Yes.
And if you were on post-release control at any point for this case, never violated any of the conditions of your supervision, the parole authority could return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes.
Now, aside from the possible prison sentence, there are other sanctions that could be ordered. You could be fined, in this case, up to $5,000. You could be ordered to pay court costs. You can also be ordered to reimburse the county for any costs of confinement, community supervision, or treatment, if any of that were applicable in this case. Do you understand that?
Yes.
You can also order to pay restitution if that's applicable. I don't know if it is, but for any economic loss any victim may have suffered as a result of the conduct. Do you understand that?
Yes.
Sorry?
I say.
You have to speak up.
Oh, yes.
Now, a few moments ago, I explained the possible prison sentence you face. I used the word possible because prison is not mandatory or required with this charge. You are eligible for probation, what's called community control sanctions. Do you understand that?
Yes.
Do you understand just because you're eligible doesn't mean you'll automatically be put on probation? It means I'll consider that if that's what you're requesting. I'm going to look at all the information and circumstances, and I'll make the decision I think is the right thing to do. Do you understand that?
Yes, sir.
If you are put on probation, it could be for up to 5 years, and as the judge, I have the discretion to order a wide variety of rules and conditions for you to follow. One of the conditions can be in order that you serve a term in the Lake County Jail of up to 6 months as a condition of probation. You understand that?
Yes, sir.
Further, if you're on probation or community control and you're violating any of the conditions of your community control, we would have a hearing in the court here for this case to determine whether you're a probation violator. If it was determined that you were, I could extend your probation up to 5 years, I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I sent you to prison then, again, it could be 6 to 18 months in prison, which could be consecutive to any other sentence you may be serving at that time or that you're being sentenced to at that time. You understand that?
Yes, sir.
Lastly, when we do come back here for sentencing, you'll have the right on that day to say anything you want me to know or consider. Your lawyer could speak on your behalf. He can recommend a sentence to the court. The prosecutor can also recommend a sentence to the court. Do you understand that?
Yes, sir.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, sir.
All right, well, do you have any questions at all regarding the potential penalties you face by pleading guilty?
No, sir.
You understand all the possible consequences?
Yes.
Do you still want to plead guilty?
Yes.
Have you had enough time to talk about this case with your lawyer, have him review the report with you, discuss the issues, answer whatever questions you have?
Yes.
Are you satisfied with the advice and counsel of your lawyer?
Yes.
Has he or anyone else made any promises to you about what's going to happen at sentencing which is inducing you to plead guilty?
No.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering the guilty plea freely and voluntarily?
Yes.
All right, then, do you have any questions for me at this point regarding anything we've just talked about? The rights you're giving up, penalties you face, what you're pleading guilty to?
No, sir.
You need to speak up.
No, sir.
Do you need any more time to talk to your lawyer before we go forward with your actual plea?
No.
Well, then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the facts would show if we had a trial. I want you to listen to her and what she says, because I have some questions for you about that, all right?
Okay.
Ms. Himmeline?
Thank you, Your Honor. Had this matter proceeded to trial, the state would establish beyond a reasonable doubt that on March 17, 2026, in the city of Eastlake, Lake County, Ohio, the defendant did knowingly cause or attempt to cause physical harm to a family or household member at the time, Michael Agapi, causing a laceration above his right eye and scratches on his body. And for purposes of the plea agreement, the state has agreed that there is a prior domestic violence conviction out of this court, Lake County Common Pleas Court, case number 24 CR 1277, dated February 18th, 2025. Thank you.
Thank you. Ms. Kovach, were you able to hear what the prosecutor had to say regarding what she believes the facts would show if we had a trial?
Yes, sir.
What, if anything, do you have to say about those facts as she presented them? Are they true? Did you do what she said?
Yes, sir.
Very well. Then regarding lesser included offense of count 1 being domestic violence of felony of the 4th degree, what is your plea to that count?
Guilty, sir.
I have with me right now a 4-page document called a written plea of guilty and judgment entry, which sets forth everything I've just discussed with you. Before I can accept your plea, I need to make sure you understand the document and that you sign it here in open court. Now, my understanding is before I came out here, you had a chance to go over that document with your lawyer. Is that correct?
Correct.
Mr. Smith, is that accurate? Did you review this with Ms. Kovach, read it over to her, answer all her questions?
Yes, I did.
Did she indicate an understanding of it to you when you went over it with her?
Yes, you did.
Is that correct, Ms. Kovach?
Yes.
So you understand what that document says?
Yes.
Do you have any questions for me about it?
No, sir.
It also appears you signed it. Did you sign it?
Yes.
And Mr. Smith, you witnessed that?
Yes, I did.
Ms. Himmeline, you as well?
Yes, I did, Your Honor.
Very well, then. At this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with her lawyer, advised of all her constitutional rights, and made a knowing, intelligent, and voluntary waiver of all those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of lesser included offense of count 1 being domestic violence, a felony of the 4th degree in violation of 2919.25. I'm going to defer sentencing, order an updated pre-sentence report, continued bond, and victim impact statement as well. Did you say we have a sentencing date?
Yes, sir.
When is it?
She had July 6th?
Well,
Yeah, July 6th at 3:30.
stick around. Yeah, that's too far.
Okay.
Stick around for a minute. All I'm doing is an updated report, and it's so. All right. Anything else for the record at this time, Ms. Himmeline?
No, Your Honor. Thank you.
Mr. Smith?
No, Your Honor.
Thank you.
All rise.
Yeah,
I'll come too.
All rise. You may be seated.
Ms. Mulligan?
Your Honor, we're here in the matter of the State of Ohio versus David A. Sanders, Jr. This is case 26 CR 583. Mr. Sanders is present in court. He is accompanied by his attorney, Mr. John Fatika. We are here set for arraignment.
Mr. Fatika?
Good morning, Your Honor.
Morning.
Mr. Sanders didn't receive an indictment, has been so for more than 24 hours. We've entered not guilty pleas as to each count and respect the request to be heard as to bond.
Thank you. Mr. Sanders, you received a copy of the indictment?
Yes, sir.
Did you have a chance to go over it?
Yes, sir.
You have the right to have me read that. When did you get it?
Yesterday morning.
You have the right to have me read that to you if you want, and I'm happy to do that, or you can waive the reading, which means I won't read it to you. What would you prefer?
We can waive it, sir.
Very well, then, as to the 2 counts in the indictment, charge you with domestic violence, felony of the 4th degree, and aggravated possession of drugs, a felony of the 5th degree. What is your plea to both of those counts?
Not guilty, sir.
All right, a plea of not guilty will be entered on both charges. As to bond, let me hear from the state first. Ms. Mulligan, what's the state's position?
Your Honor, the bond set in the municipal court's $250,000 cash surety of 10%. We understand that to be a bit excessive. The state would be recommending $25,000 cash surety of 10%. Mr. Sanders does have a prior felony record and some failure to appears. He has been to prison 2 prior times.
Give me a second, please. One of the conditions in municipal court was also electronic monitoring house arrest. Are you recommending that?
No.
I'm sorry?
No, I am not.
What about a no contact order? Are you recommending that? That wasn't part of it initially.
It's not part of the current bond, and the victim does not wish for a no contact order.
Mr. Fatika, you want to be heard on bond?
Thank you, Your Honor. We acknowledge that Mr. Sanders does have prior history. He's 35 years old, works as a laborer. If released on bond, he would reside at 9010 Portage Point Drive, Apartment A in Streetsboro. He lives there with his wife, the alleged victim. She testified at the preliminary hearing that there was no contact between Mr. Sanders and herself on the day in question. Mr. Sanders has been in the Lake County Jail for 50 days as of today. We're asking that he be given an opportunity to get out on an OR bond with the understanding that he's going to seek treatment, get back to work as a laborer, maintain the home. His wife, I think, is scheduled to serve a jail term. And if he got out, he'd be able to take care of their dogs, again, maintain the home, and come back to court employed and well on his way in treatment.
What's the connection to Lake County here?
I'm sorry, I did not hear you.
What's the connection to Lake County? They live in Streetsboro. How does
They were here
it happen? Okay.
visiting.
I'm talking to the prosecutor here. All right, bond's going to be set at $25,000, reset at $25,000 cash surety, 10%.
Thank you, Your Honor.
Next case, Mr. State versus Lee Butler. You can approach.
Thank you, Judge.
All right, this is State of Ohio versus Lee Butler, 26 CR 433. Mr. Castro, on behalf of the state.
Good morning, Your Honor. Yes, we are here for arraignment on case number 26 CR 00043. Mr. Lee Butler is here with Attorney Chad Mulkey.
Thank you. Mr. Mulkey?
Thank you, Your Honor. May it please the court and counsel, we will acknowledge receipt of the indictment more than 24 hours ago, waive defects in time, manner, place, and service of that indictment, waive its reading in open court, enter not guilty pleas to all the counts contained therein, and then ask to be heard on bond when appropriate, Judge.
Thank you. You're Lee Butler?
Yes,
Did you receive a copy of this indictment?
yes,
You had a chance to look it over?
yes.
When did you get it?
Day before yesterday.
Okay. You have the right to have me read it to you again, and like I said before, I'm happy to do that, but you can also waive the reading. What would you like at this time?
Well,
Waive it? Very well, then, as to the 4 counts set forth in this indictment, what is your plea to those 4 counts?
guilty.
No.
Not guilty.
Accept a plea of not guilty at this time to each of the 4 counts, and I'll enter the plea. Give me 1 second, please. All right, as to bond, Mr. Castro, what's the state's position on bond?
Your Honor, it was set municipal at 50,000 cash surety on F5 possession as well as misdemeanor. We would not oppose a reduction on that bond. Speedy time has been waived, and it was filed earlier today.
Mr. Mulkey, what's this defendant requesting here?
Yes, Your Honor. Respectfully, the defendant is asking this court for a recognizance bond. I explained to my client what all that means, including a new felony 4 charge for failure to appear. I conferenced with him about his means to get to court, since a majority of these charges involve OVI. He indicated that his son and daughter both have the ability to drive him to court. I've been in contact with both of them, his daughter yesterday, his son today, who showed up at the lobby of the sheriff's office. So he can get to court. He resides at 1501 East 191st Street, or East 191st Euclid Street in Cleveland, Ohio. He's 67 years old. He does have a criminal history, unfortunately. I do want the court to be aware, it does appear he has a pending case in Cuyahoga County for CCW, but it's my understanding they don't have any intentions to come and pick him up, as it were. Should he get a recognizance bond in this case, they're going to allow him sufficient time to deal with our matter here. He does
So there's not a warrant for him?
No.
He indicated there's not.
Okay, well, okay. Just asking.
Yeah, well, I know that's always a concern of the court, that we lose him before we finish our case here in Lakin. That's not going to be an issue in this case. It does not appear. This is an F5 possession charge, and the OVI is all stemming from the same incident. He's got some medical conditions he'd like to address. He has an issue with his foot. He'd like to make an appointment with his foot doctor, as well as receive care outside of the jail for his other...
Hey, what's wrong? I see you're wearing some type of contraption or brace there. You can stay seated.
Well, I have a back brace, back and neck brace. I was run over by a semi.
You got what?
I was run over by a semi.
Okay.
He hit me and kept going. And for my foot, I got a toe going into my, I got a nail going into my toe. need to be clipped, and I usually see my foot doctor every 60 days. And
How long you been in?
I've
How long have you
about
been in?
63, 62, 63
Couple
days.
months? Okay.
I came for arraignment March 26th, and I've been here ever since. About 62, 63 days I've been here.
Mr. Castro, was there something you wanted to say? I thought,
Maybe
maybe
I was-
I misread you. I thought you.
No, I did speak with the detective as well on there, and they're not opposed to any kind of reduction as well on this.
Okay.
That he was, as part with this case, and the reason why I'm special prosecutor on that was resulting from that accident.
Oh, so that's the case that you're a victim on is this case where you were hit by a car?
Yes, semi.
I read the reason why there's a special prosecutor, because you're the victim in another case, correct?
Yeah,
Okay.
I didn't know I had that on me until they cut my clothes off of me.
Don't talk about
But
that.
anyway,
All right, the court will reset defendant's bond under his own recognizance with condition, let me look here, not to drive motor vehicle. You're not to drive any motor vehicle, and you're not to use any drugs, including marijuana. You have to submit urine screens if requested. So when you're released on a known recognizance bond, you have to appear at all future court dates. If you fail to appear at a future court date, that's a separate felony you can be prosecuted for, which is actually more serious than anything you're charged with here.
that'd be no
All
problem.
right, well, I'm just I need to make sure you understand that
Yes.
if you fail to appear, you can be prosecuted for a felony of the 4th degree, which can get 18 months in prison. So after this hearing, this paperwork's going to get filed, and a judge is going to get assigned. It's going to be one of 4 judges here. That court will then set a hearing date, and your lawyer will let you know when that is. But if you don't hear from your lawyer, you need to contact them to find out when that court date is. It's your responsibility to make sure you know when your court dates are and when you're here.
Right.
They're going to let you know, but it's not their ultimate obligation. It's your responsibility to make sure you find that out, all right?
Right.
Okay. Do you have the paperwork there, the conditions of bond form?
I got conditions in mind here on both cases.
Both cases?
I can both, yeah, both.
He's got 2 cases?
No, no, no. First
I don't care about that one. But he needs to file the OR paperwork. Okay. All right. Mr. Castro, anything else you care to discuss?
No, Your Honor, thank you.
All right. Smokey?
Yeah, just for the benefit of my client, when I was conferencing with him, he relayed to me that he has full car insurance coverage, but I want to be very clear that I admonished him to not be driving, and now it is a bond condition that under no circumstances can you drive a motor vehicle.
You understand that?
Yes.
All right.
Thank you,
All
Judge.
right, thank you. Mr. Goodrich.
Thank you, Your Honor. Before you today on State versus Darrell Williams, file 25 CR 921. We're here today for sentencing. State of Ohio has had the opportunity to review the pre-sentence investigation report and is prepared to go forward, and the drug and alcohol report, and is prepared to go forward. Thank you.
Thank you. Mr. Smith, any reason not to go forward?
No, Your Honor, I've reviewed the same documents the prosecutor has, and we're prepared to go forward. Thank you.
Is there anything you'd like to say on behalf of your client?
Yes, Your Honor.
Go
My
ahead.
client takes, first and foremost, Mr. Williams takes full responsibility for this matter. Definitely realizes his wrongdoing, and he definitely did not make the right decisions in regards to this matter. He's fully aware and acknowledges his criminal past. He definitely realizes that he's made a lot of wrong decisions in his life, but I do believe this time this has been a wake-up call for him. He realizes that he needs to make better decisions in his life for himself as well as his family. In mitigation, he has recently enrolled in the city mission as of beginning May 6th. It's a 6 to 9 month program. He's currently in that program. It'll help him with drug and alcohol treatment, getting himself back on his feet, making better decisions in life, and also getting a job. And also stable housing as well too. So he's
Also
voluntarily.
what?
Excuse me.
What was the last thing you said?
About housing and job.
You said something about the state of Ohio, huh?
Excuse me.
I thought you said something about the state of Ohio.
No, I didn't. No, I didn't. say
I
that.
misunderstood you. I'm sorry.
No. There is a representative from the city mission here to speak on his behalf. Mr. Williams fortunately has not had any run-ins or brushes with the law since you let him out on bond since we were here last time. But he's definitely learned his lessons here. He knows that he needs to fly straight and make better decisions for him and his family, and he's willing to do that. So we're just asking for probation in this matter, Your Honor, fines and court costs. If you also consider credit for time served. Like I said, he's fully remorseful in this situation. He definitely realizes he needs to make better decisions in his life. Thank you.
Thank you. Did you want someone to speak from?
Yes. I don't know if you want to see this paperwork again, or do we want to judge
Sure,
it?
to me.
Go ahead, Roach.
Sure.
Sir, if you want to come on.
Well, whoever it is that would like to speak, you can stand right where it is. You can stand right there. Just keep your voice up. State your full name, spell your last name, and then say whatever you'd like me to know.
Sure. My name is Raymond Mills. That's Mills. I'm the intake coordinator at the City Mission Crossroads. And I just wanted to come on behalf of Mr. Williams to state that he has been fully compliant with our program components. As you can see in that document, we have 4 phases: the arrival stability phase, the personal development phase, the work readiness phase, and the employment and housing phases. So in those phases, of course, we have support groups that deals with the issues that Mr. Williams has. We have a resource center that helps our men with trades or get in Tri-C school, ultimately get jobs. We have DBT, we coordinate with Ohio Guidestone in regards to mental health and IOP, in addition to Jobs Retreat, which is another agency that we deal with. We also link our men up with Carmela Rose, so that if there's any insurance issues that they may have in regard to health insurance, we have Metro Health that comes on to help our guys with health situations. So there's a host of resources that we have for our men so that they can become more productive members of society. And thus far, coming in, Mr. Williams, he communicated a lot of his struggles to us, and that's the first step. Like living up to whatever part that you play in any situation that you get yourself into. And he's been willing to take whatever he's done. And one of the things, he came in willingly, not through the courts, not for the courts. He just wanted to turn his life around, and we've been able to communicate those things with one another. So he's been fully compliant to all our program components thus far, so I can speak to that.
How long is this program?
It's a 6 to 9 month program.
So what determines whether it's 6, 7, 8, or 9?
Well, it's once that individual moves on to another case manager, they have what they call an individual service plan. And so by us helping all people opposed to just generalizing with one group of people, that's what determines the 6 to 9 month program. Some men come in, you know, they have legal issues that we'll accept them where no place else will accept them. So that stay may be a little bit longer. Some people come in with disabilities, not so much physical disabilities, but you know, where they're not able to work. So getting housing for them may look a little bit different. And then we have our employment phases where some of our guys come in, such as Mr. Williams, who don't have those type of issues, who deal with the issues that he have now. We just need to, you know, we just need that transformation to take place through our program.
But it's a minimum at 6 months? A minimum at 6 months?
The minimum of is 6 months, yes, sir.
Are they residing there?
Yes,
the whole
it's
time?
residential, yes it is.
The whole, at least for the 6 months?
For the 6 months, there's no overnight stays or anything like that. You have to be there every night. We have a curfew. We have programming hours throughout the course of the day. And once your programming hours are over with, you know, if you have, but we don't hold our men back from any court situations or if they have to see probation or if they have doctor's appointments. If there's a family emergency, then we'll take in consideration whether or not that person could potentially stay overnight or anything like that. But it's a 6 to 9 month residential program.
And what if they don't show up at night? Then what happens?
Well,
I mean, let's assume you look into it and it's nothing legit. There's no.
If it's not legit, then it's a case by case situation.
I'm assuming if someone's been there for 5 months and they've done well, they may get a little more consideration.
Yeah, they'll get a consideration. So what I try to do is I try to make sure what we don't want to do is turn people back to the streets. So if it's, for instance, if it's a situation where there's a relapse that occurs, so we'll literally, you know, we'll try to have that individual get in contact with the probation or parole. And we'll get that person into where they can get the level of care that they need for whatever that situation is. So they might transition to another program from there. If they stay out, I'll try to find them someplace else.
How many people are there related to court cases versus not the legal system?
I couldn't give you an accurate number, but I'll say maybe 50%.
50-50?
Maybe 50-50, yeah. 40, 60. Maybe.
Do you work with the courts? So if someone's on probation and they're not doing what they're supposed to be doing, do you guys notify the courts?
No. That's we don't necessarily, but if the courts come to us, for instance, if that individual isn't there anymore and his probation officer or parole officer comes to visit us or to visit him at our facility, we'll let him know that he's not there. You know, but as far as us communicating back and forth with
So if the person takes off and they're no longer there, you're not going to notify the probation officer that this person's not there anymore?
No.
So how do the courts find out if the probation?
It normally happens.
What normally happens?
They find out. At some point, they'll find out. Now, now there are cases where there's release of information that we have to. There's HIPAA laws, of course, that you know of. Now, if there's a release of information, once they come to us, and the probation officer, they give us we get a release of information that we can give to whatever probation or whatever legal system that, then we'll notify. But it has to be through a release of information.
If they sign a release, then you'll take the affirmative step of notifying. You're not going to make the probation department reach out to you to find out how they're doing.
No, we could, like I said, if there's a release of information and I'm able to contact that whoever that individual is that needs to know that they're not there anymore. No, we don't have a problem with that.
You'll do it, not that you
absolutely.
don't. But I mean,
yeah.
So the person that takes off and no longer there, and there's a release of information saying, you'll take the affirmative step of contacting them.
And say, hey, that individual, John Doe, whoever that individual is, we'll take the action of contacting the proper authorities and letting them know that person isn't there anymore.
Okay. All right. Thank you, Mr. Mills.
Sure.
Is there anything else? Is there anything else you wanted to say? I'm sorry.
No, other than he's been compliant to everything that we need him to do. That's all I can say.
Okay. Mr. Williams, you have the right to address this court before your sentence. You can say anything you like. Is there anything you want to say at this time?
Yes, Your Honor.
Good.
May I say?
Whatever you're comfortable doing.
I want to apologize to the court for the time I wasted by doing what I did. I take full responsibility for the part I played. And I thank everybody in here for the patience and the time y'all had with dealing with me. And I take full consideration on the part I gotta play to make this better and make this not a waste of time to everybody. And I thank y'all.
All right, thank you. Mr. Smith, anything else on behalf of the defendant?
Yes, Your Honor. I do believe, again, Mr. Williams is on the right track here, especially engaged in this program. He definitely acknowledges his wrongdoing in this matter and that he's made, in the past, wrong life choices, and he's ready to, to confront all that and just start making better decisions in his life. Thank you.
Thank you. Mr. Geigerich for the state.
Thank you, Your Honor. The State of Ohio would entrust the court to fashion a sentence that would be appropriate in this manner. The only question with the reporting aspect from city mission is there a person who would be responsible for that this court could hold accountable if the court is not informed that he left or something like that? Thank you.
Hey, Dave, can I see you for a second? This court has reviewed the pre-sentence report and investigation, the drug and alcohol evaluation. I've considered the facts and circumstances of the offenses involved, the nature of the offenses. I've considered what's been said here in court by Mr. Smith, the defendant himself, Mr. Mills from the city mission, the prosecutor. Reviewed the paperwork that was submitted to me. I'll give this back to you at the end. You can get it at the end. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-29-11. For the factors in 29-29-12, nothing stands out factually indicating it's more or less serious. Recidivism factors, the court finds the defendant was on probation at the time he committed this offense. He was on probation at the Cuyahoga County Common Police Court. In fact, there was a warrant out for him at the time for a probation violation because he failed to appear. when he committed this offense. He has served multiple prison terms before. He's been put on probation many times before, and he's violated his probation on multiple occasions, so he's failed to comply with previously imposed sanctions ordered by courts. Failed to appear for a hearing in this case, and there was a warrant issued for him for some time before he finally was arrested on that. As for factors indicating recidivism is less likely, the court will note that the defendant voluntarily put himself into this program at the city mission. He wasn't ordered to do that. And it wasn't, we'll just see sometimes done just 2 or 3 days before the sentencing. It was done, what are we, about 3 weeks now, 3.5 weeks ago? I think May 6th, if I'm remembering correctly.
Yeah, May 6th, right.
Under 2913B1, the court finds the defendant has previously served a prison term and was on probation. That overrides the presumption for community control, permits the court to impose a prison term with the defendant's history. It's a lengthy history. It's a lengthy history of drug trafficking, which is what we're here for. Prison is certainly consistent with the purposes and principles of sentencing. But Mr. Williams, I'll give you one chance here. It's a short leash. I mean, with your history, I can easily justify a prison term, especially with dealing in drugs, and that's what your history is here. But I'll give you a chance to complete what you started. I'll find you're amenable to community control sanction. I'm going to put you on community control sanctions for 2 years. I'm going to order that you serve 45 days in jail with 45 days of credit. I'm going to order that you continue and successfully complete this 6 to 9 month program at City Mission. So a minimum of 6 months to possibly 9 months, whatever is being recommended there. You are to sign whatever releases are necessary so that they can communicate with the probation department. That needs to be done immediately. Again, you're to successfully complete that program and follow whatever aftercare recommendations they make. You're not to use any drugs or alcohol. That includes no marijuana use even. You're to submit random urine screens when requested to the probation department. They have to be negative. A positive screen will result in your probation being terminated. You understand that? You're not to screw around with urine samples, bring in fake urine, someone else's urine, anything like that. That's even worse to me than, quite frankly, testing positive. I'm not going to order any specific number of AA meetings. Whatever is recommended by the folks at the City Mission, if they recommend any, then that'll be a condition of your probation as well, to do whatever number of AA meetings a week are recommended, if any. You're to obtain and maintain full-time employment. You are to report to your probation officer as directed and or maintain contact with them as directed. So while you're at City Mission, you're still going to have to report, but they may have you report sometimes and then, but maintain weekly phone contact. But however, whatever they're requiring in terms of contact with them, you need to do that. If you fail to do that, you're going to be in violation.
Yes, Your Honor.
And you're going to need to follow the rules at the City Mission here. It seems like you're doing all right so far, but you need to follow the rules and not get into it with other people. I know there was some issues when you were in the jail here with whoever was in your pod, and I'm not getting into that. But I know there was issues there. You're going to have to deal with that with other people and get along with other people and remember what you're there for. If there's issues there that cause you to get kicked out, you're not going to be pointing the finger at someone else and saying, this wasn't my fault. It's going to be your fault if you get kicked out.
Right.
Here, court costs and supervision fees, I may have said that, but if I didn't, do that. Count 1 will be dismissed as agreed to. Bond will be released. You still have the bracelet on?
Yes.
We'll have to make arrangements to get that taken off.
Hold it.
Mr. Tompkins, anything else I should be considering here or thinking about?
Judge, we just asked for a mental health assessment as well.
And we'll do a mental health evaluation and follow whatever, if any, recommendations for any type of counseling or treatment. If they recommend that you go see someone, you gotta do it. If they recommend medication, you gotta do it. If they don't recommend anything, then you're all done there.
Okay.
Understand that? And the full-time employment is whenever it's, folks at City Mission say it doesn't get. I don't want you going back saying they say I need to work today, and so I can't do any of this stuff. It's whatever pursuant to their orders, and then once you're done, you're obviously working full-time.
Okay.
Mr. Mills, anything else I should think about?
No, that's fine, Your Honor. We'll make sure that he has a mental health assessment. We have an agency that we
I assume they can do that.
We'll make sure we get that. I'll get a referral out for that right away.
And I'm relying on you guys if when he signs this waiver to keep Mr. Tompkins up to date with what's going on.
We will, sir.
All right.
Yeah.
Mr. Williams, you understand all the conditions of your community control sanctions?
Yes, Your Honor.
Any questions for me?
No, Your Honor.
All right, I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another offense while you're on probation, a motion to terminate your community control sanctions will be filed. And if it's found that you violated, I could extend your probation up to 5 years. Up to 5 years. I can impose more restrictive sanctions against you, including local jail time, or I can. And what will happen is again, you're on a short leash here with your history. I'll terminate your probation, send you to prison. And if I were to send you to prison, it would be 18 months on each count that you pled guilty to consecutive. So 3 years in prison is what's hanging over your head. You understand that?
Yes.
And that would be consecutive to any other sentence you may be serving for some other case, if there is any other case that comes up or that you're being sentenced to at that time. I also want two more things. You need to clear up this outstanding warrant you have in the Cleveland Municipal Court for a traffic offense.
Okay.
You can't be on probation and having outstanding warrants out for you. So it's a more recent case, a 25 case. You familiar with it?
Mr. Tompkins ran it by me
This is
already.
operating a vehicle without a valid license. It was
Yeah.
just in November, Cleveland Metro Parks.
Yes, I just been down on money, so I know it was gonna take some money. So I was just waiting until I got stuff on track.
Well, you need to take care of it
I'll
so you
get
can clear
taken
up, so
care
that
of.
warrant at least is cleared up.
I got you.
And then the other thing I'm going to order, I'm not suspending your license, but I'm ordering that you do not drive without a valid license or valid privileges.
Okay.
So if you get stopped driving a car but you don't get cited for DUS, you're still in violation of your probation.
Okay.
You're not to drive a vehicle without a valid license or valid privileges. You understand that?
Okay.
So if sometimes you get behind the wheel of a car and say, "Oh, what's the big deal? I get caught. It's just no operator's license." It's 3 years in prison if you get caught driving a car. You
Okay.
understand?
Yes.
All right. Mr. Smith, anything else for the record?
No, Your Honor.
Mr. Geigerich?
Costs and fees, Your Honor?
I think I said it twice already, maybe.
Oh,
And I know I said it at least once because I thought I repeated myself.
Oh, okay.
But yeah, costs and fees. Yep. Thank you.
All rise.